Chairwoman Abrams, Vice Chair Miller, Ranking Member Thomas, members of the House Public Safety Committee, thank you for this opportunity to provide opponent testimony for substitute House Bill 1. My name is Gary Daniels, Legislative Director for the ACLU of Ohio. I understand time's limited. I'll be brief. First, this testimony addresses the impact of HB 1 on individuals and their purchase or acquisition of personal residential property. That is, we choose not to concentrate on HB 1's impact on commercial interests, business properties, and so on. It's outside of our area of expertise. Second, we recognize House Bill 1 is better than House Bill 1 as introduced. Welcome changes include exempting legal permanent residents from HB 1's provisions. I also mentioned their retroactive application. Please disregard that part of it. That's from SB 88 over on the Senate side and was not part of House Bill 1. Do not mean to confuse things here. But we're grateful for the improvements that are made via substitute House Bill 1. But it still remains what opponents have all along accused it of being. That is, it's a resurrection and modernization of the various exclusion laws stretching from the 1880s to the middle of the 20th century in this country. In this particular case, House Bill 1 forbids the acquisition of real estate, arguably throughout all of Ohio, to people with foreign citizenship deemed a threat to Ohio or the United States is largely determined by one person, the Ohio Secretary of State. The reference to HB 1 applying to all Ohio comes from HB 1's application to critical infrastructure facilities and military properties. Under current law, unchanged by House Bill 1, critical infrastructure facilities are numerous and widespread, including such nearly ubiquitous locations as railroad tracks, utility poles, telephone lines, utility lines, fiber optic lines, and also including, but not limited to, refineries, ports, trucking terminals, dams, steel plants, and much more. The point being, I believe one would be hard-pressed, even in Ohio's most rural locations, to find property not within 10 miles of any of these various locations and buildings. With regard to the Secretary of State's broad authority to create, utilize, and designate targets for property ownership exclusion, the restrictions on that authority are few. HB 1 requires the Secretary of State to consult, but only consult, several lists developed and used by the federal government to determine the risk and security status of foreign entities and individuals, but the Secretary of State is not bound by HB 1 to actually incorporate any or all of those lists. Otherwise, like with HB 1 as introduced, the ACLU of Ohio is concerned substitute House Bill 1 violates any number of at least the Equal Protection Clause of the 14th Amendment, the Supremacy Clause of the U.S. Constitution, the Federal Fair Housing Act, and is unnecessarily duplicative of the Federal Foreign Investment Risk Review Modernization Act of 2018. Instead of welcoming newcomers hoping to build a future for themselves and their families in the Buckeye State, HB 1 treats people as suspicious, undesirable, disloyal, and security risks, the same discredited rationales used throughout the sordid history of exclusion laws in our country. HB 1 supporters, we believe, simply have not made an effective case this type of legislation is needed. For these reasons and more, the ACLU of Ohio urges this committee's rejection of substitute House Bill 1. Thank you, Madam Chairwoman.
Thank you for your testimony. Members, do you have any questions for the witness?
Yes, ma'am.
Ranking Member Thomas.
Thank you, sir, for your testimony. Can you drill down a little more on the constitutionality of this particular issue and talk about that?
Mm-hmm. Yeah, so it's the claims that have been brought, through the chair to Ranking Member Thomas. At least some current litigation. This topic from other states gets into a variety of different issues, some of which I have mentioned here. Equal protection under the 14th Amendment, which prevents discrimination based on a number of things, including national origin. But here, that's exactly what we see going on. Enforcement of immigration laws and matters with regard to foreign policy belong to the federal government, not the states. The states can tweak it, deal with it somewhat in a very limited manner, but we would argue not in this particular respect, and not constitutional, but still statutory, the Fair Housing Act, which prevents discrimination with regard to a variety of things, including national origin. So we see all of this here in substitute House Bill 1. Now, litigation has been mixed. For instance, in Texas and Florida, those lawsuits right now are currently bogged down with regard to standing. That is, the ability of people to come in and bring a legitimate lawsuit. Some of the bills we've seen, like in Texas and Florida, are not so clearly defined. For instance, in Florida, they use a term in their law, domiciled, but they didn't define that in the law. So there's been some fight in courts as to whether the plaintiffs in these cases have the standing to bring the lawsuit. So these lawsuits really haven't gotten too terribly much to the merits of the case. It's a lot of back and forthing right now about the standing of the clients.
Okay.
Okay,
Thank
thank you
you.
very much. Representative Plummer.
Thanks, Chair. Gary, does you or the ACLU believe in secure borders in this country?
Yeah. Through the chair to Representative Plamer, of course we do. But we don't see this as providing the type of security or preventing the types of situations that I think a lot of supporters talk about. I think actually amendments to this bill make that case, actually, because if security was such a paramount concern with regard to this bill, why make those as exemptions for green card holders? Now, we like those exemptions, but you know, if the people, anybody here from China, or the other assorted countries subject to this were truly a threat, why make any exemptions whatsoever? Why lower the ratio of miles that apply to certain sites? So again, we appreciate the exemptions, but we think it also makes our case that this has less to do with security than some supporters say.
Okay. Quick follow-up.
Well,
You're killing me.
I only had
Both of
1/10
you
of
are
the
killing
questions
me.
that Cecil did down there.
Yeah, that's true. That is true.
Would it be safe to say the 15 million plus people that crossed our borders illegally probably shouldn't own houses near critical infrastructure? Would that be a safe assumption?
I'm sorry, it was through the chair to the representative. Can you repeat the question again?
Would it be a safe assumption to say the 15 million plus people that crossed our borders illegally should probably not own houses near critical infrastructure? Is that a safe assumption, or is that just me reading into it?
Through the chair to the representative, those matters that you're talking about are not impacted by this particular bill. What we're talking about here is people who are here, when you talk about entirely legally, who are getting shut out of the process and the ability with regard to home ownership. Undocumented people and their ability to buy property seems to me to be a separate matter from what exactly this bill here addresses.
Okay.
And I should mention, too, people accused, as I say in my testimony, accused of no wrongdoing. They haven't been arrested, they haven't been indicted, they haven't been convicted of anything.
Thank you for your testimony. Any further questions? All right, seeing none, thank you.